So
it seems like one of your arms is trying to put out a business, another part of your business. Like
I mean,
your trust formation business is trying to put out your probate business.
right. But the problem is that I'm never going to be able to do enough trust to get rid of the things because there is way more people that don't plan than there are people that plan.
Really.
But yeah, that's a good point. I'm trying to, kind of put myself out of business as far as the probate arm. But the what I can tell you is that dealing with trust administration, there's certain challenges that always go into that. But from my experience, there's just it's just so much easier for the family to deal with the administration of a trust out of court without the exorbitant fees, without the exorbitant waits in time. I was in court yesterday. I'm sorry, not yesterday, Monday. I was in court Monday morning. And we were wrapping for probate. This was somebody that had died a couple years ago. And I found an account a week before the hearing, a week before the probate was to close.
2 years later.
Yeah, 2 years later. So we had to scramble and update the inventory, amend the petition, and get it filed. Well, the court, the San Bernardino County Court, where I have a lot of my cases, they're backed up. Everybody's still reeling from COVID, the pandemic, the Great Resignation. Everybody's retooling and trying to get their staff up to where it was before. Well, the court, because it was a week before, the court didn't get the documents in time, didn't have the documents in front of him when the case was called. I had to verbally let the court know what had happened the week prior. And the court said, well, I'm sorry, I'm not going to hear your matter today. There's been too much that has happened. If we have an updated inventory, I'm not going to be able to hear the petition today, so we're going to have to continue it. And you would think, oh, well, that's sad, a continuance, but at least the beneficiaries will get their money, maybe in a month or so. The court said that my earliest available date is in the middle of August. So, because we found
right now. For those who are going to do this podcast later, it's March right now.
Yeah, it's March right now. So it's 5 months out, just because we found an account that was a week before the hearing.
Yep.
And the courts are backed up. There's not enough judges. There's not enough staff. And so dealing with the court and the court process is just usually an awful experience and is to be avoided. I mean, I don't have anybody at the end of a probate. I do all the probates in the office. And I'm a specialist in the area. I never have a client at the end of a probate say, gee whiz, Chris, you made that such an easy process for us. Thanks so much. Never have that conversation. It's an awful process every single time. And we're good at it. If you don't have an attorney that knows what they're doing, or you don't have an attorney at all, that year and a half to 2 years that I'm talking about, that turns into 5 years if you're trying to do it on your own. And so, yeah, I mean, that's what I would say is that you don't want to deal with the stressed, you don't want to have to deal with the delays. I had to go back to my office, tell the client, look, I tried everything that I could in order to get the matter heard that day, but unfortunately, everybody's going to have to wait 5 more months. And the client's not happy. The beneficiaries aren't happy. They've already been waiting a year and a half or so, and now they figure out that it's going to be another 5 months just because the court's backed up. So.
Crazy. That's crazy. So how do you help the client balance between, and I get this a lot when I'm talking to my clients, how do you help them balance between having enough money for themselves and using themselves and leaving a legacy for their kids. Like most of the people, they don't spend, like my dad says, I'm going to spend the last dollar, in an ambulance on the way to the hospital to buy a hot dog. So I'm not going to get any, which is fine. But a lot of my clients are saying, I don't want to spend a lot of money. They're afraid that they're going to run out of money. So they don't want to give up certain control that might be beneficial for advanced estate planning to give up control ahead of time. So how do you balance that kind of push and pull that you have?
Well, I mean, that's really something that where I lean on, um, you know, somebody like you, Stuart, to really, advise the client as far as, so you have these, millions of dollars, how much is it that you need to live on? How much of it can you give away? I mean, advanced estate planning, dealing with estate taxes is really about just giving away your assets, either giving it away to charity or giving it away to your kids, doing it in a way that will not trigger gift taxes or uh, 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 generation skipping transfer tax. Um, but it's a but if you're over the exemption amount, the way to minimize estate taxes is making sure that you don't end up, dying with more than the exemption amount. And so that really involves getting rid of the assets in some way. And so, yeah, it's an issue where every family is different. There's the issue of dealing with the client's insecurities as far as trying to figure out how much money they need to hold on to. But then there's also the issue of, well, if I give this to my kids, then what is that going to do to the family? How much do I want to tie it up into some type of dynasty trust that goes on for tons of decades, or do I want to give it to them outright? Will this money destroy my kids? Will it cause them to leave the workforce and for them to have unproductive, unsatisfying lives?
Yeah.
And so the issue of whether to pay the tax or not, whether to give it away or not, it's multifaceted. So part of it is dealing with how much do they need to live on, but also a big part of it is what's in the best interest of the family.
Yeah. So you brought up me as financial advisor. What are things that we could do to help with the process for you, or that our clients should be thinking about, or we should be bringing up to our clients to make sure that they're well prepared? Of course, I inquire, do you have a trust? Do you have a will? If I hear, oh, I just have a will, then we need to make some adjustments. But what else do we need to be doing to help make this process easier?
Right. So, I mean, the main thing that's beneficial about somebody like you, Stuart, is that you are less transactional based than I am, and so from an estate planning attorney, it tends to be more transactional. I'll see my client, and then if they want to make updates, then great, then I'll see them again. But sometimes I don't see them for a long time. There's no yearly meeting a lot of times with a lot of my estate planning clients. And so, financiers really are, kind of more on the front lines as far as, really understanding year by year as far as what that client's going through and what their needs are. And so I really appreciate, you, Stuart, in, asking those questions. Well, do you have, a trust? Do you, are you thinking of issues related to estate taxes? Are you thinking about issues related to what you want to have happen with your wealth after you die? Because oftentimes I'm sure what you would say is that it takes more than one conversation to really convince a client to come in and see an estate planning attorney and actually move forward on it. So just continuing to have the conversation with your clients, I think, is the main thing. And then, as far as what is great about having a financial advisor when the plans are actually set up is that it allows it to be much less likely for there to be, kind of oopses or, things that are left out of the trust or left out of the estate plan that were done, accidentally. Again, as I said in the beginning, setting up a trust is like setting up a bucket. And so, you want to make sure that everything is in your bucket. You don't want to have an empty bucket. And so, I give clients instructions and say, look, we're going to take care of all of the real estate for you, but it's going to be up to you to, take care of these other things. If they have a financial advisor, then they are just so much better positioned to have somebody, help them out with the other investments and the other assets as far as making sure that all those things get into the trust.
Yeah. So this is all the rage. AI is all the rage. So how's it changing and affecting your business? Is it making things easier for you? Is it? I can't imagine you're feeling in danger of AI replacing you in any sense of the word, because, as you said, everything's a unique strategy. But how is it helping your process, if at all?
Yeah, that's a good question. I mean, AI. What I would say is places maybe that it's helping the profession is that it makes it so that finding legal research is easier. And so if I have to research an issue, it makes it a lot more likely that I, can get to, what that, very, fine issue is that I'm dealing with in a particular fact pattern might be, versus, when I started in law school, we still had, reams and reams of books, and you had to, go through this big long process of trying to figure out, how to find a certain case that dealt with a certain. It's definitely helping in as far as drafting goes, making it so that it's a lot easier to draft documents and pleadings for the court, there's I don't have to deal with as much where I have staff reviewing things again and again to make sure that everything's perfect before it goes out the door. And so there's a lot of tools in AI that can help with that. Other than that, I would say that AI is probably at its infancy. I'm sure that AI over the next 5 years is going to be something that's going to be completely way more advanced than it is now. And so I think that it's just going to, the average attorney is just going to have a lot more advanced tools at their disposal in practicing law.
Yeah, I feel like there's been a lot of analogies, like with CPAs. There was questions when the spreadsheet was invented, are CPAs going to go away? And of course, they're busier now than ever, right? Mm-hmm. And my feeling is, while AI can help manage money and do research, that there's always people that are wanting to talk to somebody about what they think is going to happen and how that affects their very particular situation and what should be done about it. And I think it's going to, that the thing that AI can't replace is being human with other human beings, right? So I think that's where you and I, we have a lot of interaction with other human beings. So it's definitely helped with the productivity on our side as well. So I think we've clearly covered the biggest mistake somebody can make in estate planning is not planning for their estate, right? But particular things that have really stand out to you that people do, and or not to tell on any other estate planning attorneys, but are there things that you've seen other people do, attorneys, that you're like, oh, why did they do it that way? They, what should people be aware of?
So what people should definitely be aware of is that the estate planning practice as it existed in the 90s and the early 2000s is a lot different than the estate planning practice today. So if you had a trust that was done in the 90s, even if it was done by a really good estate planning attorney. A lot of those practices are different today. So in the 90s, we had this $600,000 exemption from estate taxes. And so one of the main issues for most estate planning attorneys was helping avoid estate taxes because all you needed was, a life insurance policy, maybe, a home or a 401k, and then all of a sudden you're over the exemption amount. And so estate taxes apply to, more the common Joe, back in the 90s. And so what estate planning attorneys did, and what, a lot of, these kind of document preparer services, still do, is they just, as a matter of course, created these AB trusts. And there are, the way that an AB trust works is that you want to, go back to that bucket concept. Well, on the death of the first spouse, it's like there's a guillotine at the top of the bucket. And when the first spouse dies, the guillotine comes down and splits the bucket in half, and half the assets get moved over into an irrevocable trust for the benefit of the surviving spouse. But the terms of that are fixed, and the latitude as far as what the surviving spouse can do with that irrevocable trust is also restricted. And so the advantage to that was is that it maximized the estate tax exemption. And so if you had a $600,000 exemption, you could double up on the exemption and you could pass down $1.2 million to the next generation without incurring any estate tax. But that issue has gone away. We're at a $13 million exemption right now. We have something called portability, where you can file an estate tax exemption and port over any unused exemption amount. And so the need to have these AB trusts, just as a matter of course, for the typical, husband and wife who's been married forever, they have, joint children that they have together. It's not necessary. It is a burden for the surviving spouse if they're left with one of these AB trusts. And so what I would say is you just want to make sure that these plans get updated. Obviously, life happens. The plan that you have when, Johnny is 7 is going to look very different than when Johnny is 35. But on top of that, practices change, estate tax laws change, the probate code changes. And so you want to make sure that you have a trust that is updated and doesn't have some of these, outdated issues going on.
I think, and you'd even be surprised. I know from my own personal experience, we looked back at our trust that we hadn't looked at for a while, and there were people named that were going to be executors and helping us out in various areas that weren't really in our life anymore.
Right.
And don't even really realize it. I mean, obviously, cases are the ex-wife is still named, and some people don't want that to have happen, or some people do. Many amicable divorces I've had experience with, but not always. And so just taking a look how often do you think they should take a look at their trust?
What I would say is that it's a good idea to, dust it off and make sure you look at it probably every, 3 years or so. Make sure that it still says, what you want it to say. What I tell clients when they have estate plans through us is that, if you haven't heard from us in 5 years, then, it's probably a good idea just to pick up the phone and give us a call just to make sure that there isn't any reason that you need to come in.
Yeah, that sounds great. Well, I think when we covered a ton of material, I really appreciate all the information you provided. It was super helpful and learning experience for me, and very valuable when I'm going to be entering my conversations. So, Chris, how can people get a hold of you?
So probably the easiest way to get a hold of me is so there's a place on our website where you can actually send a message, and so that's an easy way of getting a message to me. And so our website is, I'll say it and then spell it. It's albshulaw.com. So it's ALB as in boy, SHULAW.com.
Wonderful. All right. And of course, if you can't figure out that spelling, you can always reach Chris through me. And I can be reached at Stuart@CruiseAssetManagement.com, and Cruise is KRUSE. We also have a YouTube channel at YouTube at Cruise AM, where we publish some quarterly market outlooks and some other hopefully timely market information. So I've been your host. It's been my pleasure to host you on Money Talk Viewpoint. It's the financial blog for CPAs, estate planning lawyers, high net worth, and those that service them. And my name is Stuart Cruz. It's been a pleasure to host you. And as we say here at Cruz Asset Management, thank you so much, Chris.
Thank you, Stuart. It's been a pleasure.